Very good evening, sir. I welcome all of you on behalf of Pusa Road CP Study Circle and on my own behalf and all the attendees, sir. And today we have a webinar on the scope and opportunity for Chartered Accountant in Nclt, Nclat and IBC. And on this subject, we have the authority CA turned advocate Arun Saxena is with us. Arun Saxena is not new to us, to our study circle. He is a founder member of our study circle and regularly visiting us and giving his knowledge, thoughts to the member of Pusa Road CP study circle. He is practicing in the Nclt, Nclat code, CLB code, and having a expertise in corporate merger, demerger and IBC. He is the member of Corporate Law Committee of PhD Chamber of Commerce, Committee for Insolvency and Bankruptcy Code of Associate Chamber of Commerce, Executive Member of National Company Law Tribunal Bar Association, New Delhi. He is also a Technical Director of Training Program for Office of Official Liquidator, Ministry of Corporate Affairs, New Delhi, organized by the ICI. He is also the convener of Company Law Research Committee of NIRC of ICI and is the visiting faculty of Indian Institute of Corporate Affairs of Ministry of Corporate Affairs. He conducted so many seminars, webinars, and share his knowledge on the corporate merger, demerger, IBC. And I remember when he was in practice in CLB, there was a few chartered accountants who can count them on the fingers, and he is the one of them. And very well, he is getting his score in CLB, and the success ratio of the judgments or cases argued by him is very high. And I wish him and once again welcome him, sir. And over to you, sir.
Thank you, Rajesh ji. Thank you, Sunil Dhamija ji and Ashok Bhartiya ji. Rightly said that I am a founder, one of the founder member of Pusa Road Study Circle.
Sir.
So I am
not
at home. I am at home. So Rajesh ji said few words about me. That's his greatness. That's true that I have converted and my profession from CA to advocate. By heart, I am a chartered accountant, and that feeling will never go that I am a chartered accountant, because that profession has given me everything. And in initial stages, when everyone was doing audit, taxation, sales tax, and other areas of the practice, I was doing company law matters. So I will say one thing very openly, that I am not very much aware of the reasons why our members are not opting a branch for the practice, a company law as a practice. We do not have more number of the members, those who are making practice in company law. See, we are doing and we are expert of audit, we are doing taxation, we are doing indirect taxes, customs, everything. But there are only few members who are doing the practice only for company law. And one should not forget that the practice of the company law is not just filing of the e-form, appointment of directors, annual returns, allotment of the share capital, and like that. See, company law practice is merger acquisitions, compromise schemes. See, we being a chartered accountant, who else will be the better to draft the schemes for the merger acquisitions? And I am very sure many members must be drafting these schemes. And in drafting the scheme, valuation is being done normally till this year, January, chartered accountants were doing the valuation. When we can do the valuation, we can draft the scheme. Why can't we appear before the NCLT or the court for approval of the scheme. See, in old Companies Act 1956 also, or before 2016, when NCLT was not there, Company Law Board was there, then also Chartered Accountant was authorized to appear before Company Law Board. And in Company Law Board, lot of jurisdictions were there. Now the NCLT has come, so lot of jurisdiction of Company Law Board, High Courts have been shifted to NCLT. The NCLT is formed only in 2016. Till that, Company Law Board was there. And Company Law Board was being represented by majority of the advocates, not chartered accountants. I had the opportunity, I was one of the few people who were appearing before Company Law Board in operation and mismanagement matters. So now opportunity has widened, because not only you can appear before NCLT. In old days, when Company Law Board was there, the appeal of the Company Law Board used to be filed in different high courts of the jurisdiction. And high court, chartered accountant cannot appear. Now, Nclat has been constituted. The appeal against the orders of Nclt will go to Nclat. And Nclat also, you as a chartered accountant can appear. So I will discuss today what are the jurisdiction of Nclt, Nclat, what kind of the petitions are being filed, and how it is to be filed. And I will give finally some of the tips as per my experience, how to appear before Nclt and Nclat. With this background, I will start first of all transfer of jurisdiction of Company Law Board, High Court. So Company Law Board entire jurisdiction has come to the Nclt, which includes permissions and the approvals. Number two, matters relating to compounding of offense, merger, acquisitions. Then very important thing is you must have received the notices from registrar of companies for striking of the name. Striking of the name, if you go for the revival of the company, that is also this jurisdiction before Nclt. Third thing is very important is the approvals and this permissions, like 59, section 59. See, we have gone through so many matters where shareholders have sent the shares for the transfer, and transfer agent or the company is sitting on that. They are not either refusing or not transferring the shares. As per this section, any party, aggrieved party, can approach to Nclt under section 59, filing appeal, and make have the direction from Nclt to get his or her shares transferred in his or her name. This is very good opportunity. There are a lot of matters coming, non-transfer of the share, late transfer of the shares, rectification of the shareholders registers. So this is one of the opportunity or jurisdiction, I will say, before the Nclt. Second is compounding of offense. So this is very big chapter, before also this Nclt, this jurisdiction was with CLV. See, we have to make our concept very clear. Wherever there is a violation of any section of Act, there are the provision for the compounding of offense. There are few offenses which are not compoundable. Like if there is a fraud, then these kind of the offense cannot be compoundable. But majority of the violations are compoundable. How to file this petition before the Nclt, I will take up later. First, I will go for the jurisdiction only. So, jurisdiction of compounding of offenses with Nclt. Number 2, permission and approval. 159, section 59 I have discussed. Second is very important, reduction of the capital. Reduction of the capital is if company has more reserves and surplus, accumulated profit, and they don't require for the further business, then they can go for the reduction of capital and pay to their existing shareholder the capital. For that purpose also, that company has to go for the permission from Nclt. I am just narrating which are generally and mostly applications are being filed. Otherwise, a lot of applications are being filed for other sections also. Number 3 is jurisdiction of operation and mismanagement. Sir, operation and mismanagement is we must have gone experienced so many instances where in companies shareholders have disputes among themselves, or directors have dispute among themselves regarding the shareholding, regarding directorship, regarding siphoning of the funds, or any other illegal activities done by one group of the company or second group of the company. Then the petition goes under section 241. So 241 eligibility is if we have the capital, company having the capital, then 1/10 of the paid up capital, of the paid up capital, or 1/10 of the number of shareholders, whichever is less, they can go and file the petition. But in old Act, there was no relaxation under this provision. But new Act, there is one relaxation has been given, and jurisdiction Nclt has power to condone this or give the relaxation in case of a fit case. Suppose the shareholder company has done a fraud, and it is apparent fraud, and I being a shareholder, I am only having 9% shareholding, and I am not 1/10 of the number of the shareholders also. So according to the old law or this law, I cannot go and file this 241 petition. But now, if that is the case, fit case, you can go for the waiver of this condition before Nclt. See, Tata case, the same application was filed by the opposite party for relaxation of the this condition, waiver of this condition. So filing of 241 is dispute amongst the shareholders and the directors. Third is 252. Petition under 252 is appeal against the order of 248, section 248, by the registrar of companies. See, last year or year before last year also, you must have heard more than 2 lakhs companies have been striked off by the ROC, because ROC has been given a power under Act. If he has reason to believe that any company, either it is not operating any business, or it has not filed annual return and balance sheet for continuous 2 years, then ROC will issue a notice, and after following the procedure, if reply is not satisfactory or company has not given any reply, then he will strike off the name. If company is striked off, then directors' signatures, digital signatures are also deactivated. For that purpose, for revival of that companies, any interested party can go to the Nclt by filing the appeal for the revival of the company. And in revival of the company, one must understand very clearly. In filing the application, you have to make out your case whether when application,
lastly,
when the company was striked off, company was doing business. That can be supported by the financial statements, or we can have a case where company has not done any business for years together, 10 years, 15 years, but company has a very valuable property. Then also you may go for the revival of the company. Or if some proceedings, legal proceedings is pending against the company, then also you can go for the filing of the appeal for the revival of the company. So this is one of the jurisdiction before the Nclt. Now I am coming to a very important jurisdiction which I mentioned earlier. That is the merger, acquisitions and scheme of arrangement. Section 230 to 235. So now, if we see today's scenario, the compliances are so strict, and non-compliances are very costly because penalties are heavy. So whosoever group was having good number of companies, non-working companies, investment companies, compliance is the essential. To avoid that, lot of group have decided to merge that companies into one company to avoid the cost, to avoid the tension for filing the annual return and balance sheet, because there is not much transaction in the company. So we as a chartered accountant can very well draft the scheme, get the valuation done, and appear before Nclt for the approval of the scheme. I will come to later in the detail how petitions are to be prepared and everything. So these are the main jurisdiction of Nclt, where I can appear as a counsel, as an authorized representative, not counsel, but authorized representative. This is the jurisdiction under Companies Act. But you must have, everyone is aware, Insolvency and Bankruptcy Code. It came, and now less than 3 years, lot of amendments have come, lot of changes have been done. So Nclt has jurisdiction for IBC also. In IBC, normally 3 types of the petitions can be filed. Section 7, Section 9, and Section 10. Section 7 is filed by a financial creditors. Section 9 is filed by operation creditors. Section 10 is filed by company itself. So briefly, I will tell that financial creditor can file a petition for a financial debt which is outstanding and due, which is not paid by the company. That company is called corporate debtor. So in initial stages when this code came, the limit amount, threshold limit was rupees 1 lakh. But now it has been changed to rupees 1 crore. If amount due is more than 1 crore, then the financial creditors can file a petition under Section 7. There is one more thing. Who is financial creditor? Financial creditor who has given the loan or finance to a company under any agreement against the interest or any other return. But there was an amendment that the flat owners, allottees, will also be included in the explanation given in financial creditors definition. So when allottees were included as a financial creditor, there was a rush of the filing of the petition. Every single allottee was coming and filing the petition. So there was a problem. There was a rush, although there was a genuine problem of the builder also. Suppose project is completed 80%, 90%. There is 1,000 allottees. One allottee has some problem. He came to the Nclt and filed the petition, and CIRP process is started. The fate of rest of the 999 is in doldrum. So what has been amended again is, now at present, either 100 allottees or 1/10 of the total allottees, they can file the petition as a financial creditor. So chartered accountant can file this petition also. And if it is admitted, then you can involve in the CIRP process as a consultant, as a RP. I will come later. Then liquidator. So whole process can be involved, and the chartered accountants can be involved in whole process of the IBC. Second kind of the petition is Section 9. That is operational creditor. Who is the operation creditor? If I have provided any services or goods to any person, and that person has not paid my dues, unpaid invoices, then the operational creditors can file the petition. There is some procedure also. Procedure I am not going to discuss in detail. They can file the petition. But here one thing very important. That first is, there should not be any persisting dispute. If there is a dispute, then operational creditors petition cannot be sustained. A dispute can be in the form of that some arbitration is pending, some case is pending, or the corporate debtor has raised some dispute before issue of the notice. Very important thing, before issue of the notice. It's not like that, suppose I am a corporate debtor and someone has raised me the bill, I am not paying it. He has given the notice under Section 8 to me for the filing of the petition. suppose I have not disputed earlier, I cannot dispute the dues after issue of the section 8 notice. If there is a genuine dispute, it should have been earlier, before the issue of the notice. So disputed debt cannot be claimed under IBC section 9. Third, section 10 petition can be filed by the company itself. If company is board of directors are of the opinion that the company is not able to run its business is not viable, they cannot sustain the repayment of the loan or liabilities, they can pass the special resolution and file the petition under section 10 for CIRP process. In IBC, there are three things. First is filing of the application, then admission of the application. If application is admitted, and then CIRP process will be started. CIRP process is, initially it was for 180 days. Now it is 330 days. During that period, any purchaser can come, bid will be invited, purchaser will come. And if there is a resolution to this problem, someone can take up, matter ends here. If there is no resolution plan, or the RP is of the opinion, then there cannot be any resolution plan, then it will go for the liquidation. Then liquidation process will start. In all these processes, chartered accountant can contribute in different capacity. Then comes Nclt, LAT, Appellate Tribunal. Appellate Tribunal also, all the chartered accountants can appear before the tribunal, and all the assets, all the orders of the company law tribunal, Nclt, if anyone is aggrieved, the appeal can be filed, will be filed only in Nclat. It can be filed within 45 days, extendable to another 45 days. There is a strict procedure to file this appeal also. I will come later. So in Nclat, only appeals are being entertained and chartered accountants can appear before it. Now I am coming to the real opportunity, how to file, how to approach the Nclt, and how to involve ourselves in Nclt proceedings. First of all, filing of the application, petitions, or any pleading. So it's very good that Nclt rules have provided different forms for different petitions, right? So we have to use that forms in petition. But form does not mean you just fill up the form and file it. No, it's a case-to-case basis. In this, you have to give the particulars of the petitioners, particulars of the respondents, then jurisdiction of the benches, then facts of the case, then what is your legal issues, and then prayer. What is your prayer? So we have to be very careful in drafting our prayer also. And the jurisdiction of different benches is all depends on the registered office of the company, where registered office of the company is situated. Suppose my registered office is situated in Lucknow. My entire corporate office is in Delhi. If someone filed petition against me, then my jurisdiction of that petition will be Allahabad. And jurisdiction is not based on the creditor. It depends on the debtor. where debtors registered office is situated. So filing of these forms and necessary these petitions is very important. See, you have to give the facts very briefly. Someone of the opinion that give very voluminous petition, it will get the good effect. No. Voluminous petition will not make any effect. You have to write a very valid thing. Suppose you have to say to the company, against the company, that company, the other director has not allotted me shares and he has treated my money as loan. So I have to describe and I have to put some documents in my support that money was given for the allotment of the shares, not for the loan. So every averment, if I make, should be supported by relevant documents. That documents also, it should be total clear. It's not for the sake of document just you file it. You have to see it should be very clearly printed. If it is not clearly printed, you have to get a typed version. Then only they will accept, otherwise they will not accept. And annexures should be very clearly marked in the petitions and it should be properly indexed to the petition. Apart from this, petition, annexures and index, these two other things are very important documents additionally to be filed. One is date and event of the matter. It's a separate thing you have to prepare according to your facts, disputes and prayer. What is the date and event of the matter? Very clearly, very briefly, and then one is synopsis. Because sometimes the bench see the synopsis and they will come to know what is the issue involved in the petition. So this is one thing very important. Synopsis, date of events are to be filed along with the petitions to NCLT. And filing is online. Some of the benches, Bombay, Delhi and Chandigarh are online. Others are not yet online. But apart from the online, you have to file the hard copies of the petitions also. Next is, suppose I file the petition for this compounding of offense. So I have not to file the petition for compounding of offense to NCLT. We have to file the petition to Registrar of Companies. And Registrar of Companies will examine my petition, and if the volume of the penalty is more than 5 lakhs, then he will refer to NCLT. And if it is less than 5 lakhs, it will go refer to regional director. And then NCLT will take the necessary decision. So applications are to be filed for compounding of offense with Registrar of Companies, and Registrar of Company will send to NCLT or RD, and then NCLT will fix up the hearing for the petition, and then CA can appear, any counsel can appear in that. Second thing is, as per Companies Act, now the valuation of the shares, valuation for further issue of the shares, valuation for this exchange ratios, valuation for the purpose of purchase of minority shares, or declaration to be given in voluntary winding up. That declaration is given, then valuation is required. That valuation can be done only by registered valuer, not by simple chartered accountant. So for chartered accountant having experience of more than 3 years can go for the registration with IBBI. IBBI conducts the exam. The candidate has to clear the exam, then it will be registered valuer in the list of the regional this IBBI. So this is one of the very, very important field for the practice, because lot of valuation is being required in the proceedings of the merger acquisitions. In IBC proceedings, the valuation is required for the valuation of the assets of the corporate debtors by 2 registered valuers. So registered valuer is another opportunity for a chartered accountant for to do the practice under company law and the Nclt. Next comes the resolution professional. Resolution professional or interim resolution professional. Under IBC, when a petition is filed, application is filed under section 7, 9 and 10, and if it is admitted, then CIRP process will be started, and that will be headed by interim resolution professional and resolution professional. First, interim resolution professional is to be appointed for 30 days. Initial work he will do. He will give the advertisement. He will take charge of the hold of the assets of the company. He will invite the claim, give the advertisement, and then he will constitute the COC, Committee of Creditors. And in first COC, his period terminates. So COC has the power either to retain the same person as a resolution professional or to replace IRP by any other resolution professional as RP. So I can act as a IRP, I can act as a RP, and then after CIRP process, if company goes into the liquidation, then the same RP can be appointed as a liquidator also. So you must have seen nowadays for the last 2 years, a lot of members have chosen to become an RP, and they are doing very well in the practice of the IBC. See, fees are very good. See, liquidation fees on percentage of the recovery. So this is very good opportunity for the professional. For that purpose, RP, you have to clear the exam of IBBI and registered with the entity, that is ICAI or ICSI or Institute of Cost and Works Accountant of India. So what we have, the opportunities are, first is appearance before the Nclt, Second, to act as a registered valuer. Third is to act as a RP or IRP. Fourth, as a liquidator. Fifth is a registered valuer. And other, for senior members, the opportunity is to become the technical member of the benches. So technical member of the benches, the qualification is member of the institute, having 15 years of experience, they can be appointed as a technical member of the benches. Minimum age is there. Minimum age is 50 years. Maximum age is 65 years. And term of the appointment is 2 terms of 5 years each. So if you wish to become a member and have the opportunity to avail the government facilities and government aura, you can be appointed as a technical member of the benches. So as of now, more than 22 benches are established now. Initially, it was only 11 benches were established, and more than 50 members, approximately 50 members are there. So this is one of the opportunity for the senior members. Now, I will come to the practical aspect of the these appearances and filing or technical tips. First of all, I will come to the compounding of offense. Compounding of offense, if you file the petition, make sure that in petition, all the offenses are covered in one petition. Because suppose you have not filed the annual return or balance sheet and violation is made for the last 5 years, and you have filed the compounding application only for 2 years or 3 years or 1 year, but for the next 3 years you cannot file the compounding application for the same offense. So be sure you have filed all the applications together for every year. Fortunately, till September 2020, there is a scheme going on. CLSS members can avail that scheme without compounding. So in compounding, you have to make sure that your default is made good. Without making default good, your application will not be accepted. I give example. Suppose there is a non-compliance for appointment of company secretaries in certain companies, and default is continuing. You have not appointed, and you file the petition, your petition will be dismissed. You have to first make default good, say about you appoint the company secretary and then file the compounding application, it will be accepted. There is one exception to it. Suppose my defaults are such nature that cannot be cured. Then what is the position? My defaults are such that cannot be cured as of now. I give example. I have issued the prospectus 2 years, 3 years back, and there was a mistake in the advertisement giving the prospectus. Some information was wrongly given, and later on it came to knowledge by ROC or any department or yourself that this information is, there is a violation of some clause. So now my plea should be, this kind of the offense I cannot make good now, because if I give after 3 years that advertisement, that will not serve the purpose. So in one matter, company law board, not the NCLT, company law board has allowed the compounding in such matter, that if this default is not curable, then it can consider according to the circumstances. Now I am coming to jurisdiction of the benches. Normally, jurisdiction of the benches are as per the registered office of the company, as I told earlier. But under NCLT rules, the benches have this principal bench of Delhi. The president of the NCLT has power to transfer any matter to one bench to another bench, one bench to another bench, anytime on the making of application, if there is a fit case. I am giving a very good example for the merger. Suppose I am planning to merge 10 companies. Out of 10 companies, 5 companies are registered office in Delhi. 2 or 7 companies are in Delhi. 3 companies are in Haryana. So, according to law, I have to file 2 petitions for the approval of the scheme. One is NCLT Delhi bench, and second is NCLT Chandigarh bench. But if I file an application under rules of the NCLT, then NCLT can consider that for the sake of convenience and the reduction of the cost, they can allow to file all the petition at the New Delhi, where the registered office of the transferee company is situated. NCLT has passed certain orders to this effect. So, if such a situation, you can use this rule and file a petition application before principal bench and get the approval. And after having the approval, the scheme can be filed in before one bench instead of 2 benches. Third is operation mismanagement, which I want to just share with you. What is operation? See, if there is a dispute, there can be an illegal act. Illegal act can be operative on other party by one party. But one thing is very, very peculiar here. The act of a person can be operative even if it is illegal. I give example. I am in the company since incorporation. I am a promoter of the company, and I have a stake in the company in the form of the loans and the equity. But I am the minority shareholder. The others, because minority shareholder has no say. What company did it? Majority shareholder did it. Legally, they have allotted further share to another parties. And I am reduced to almost 1%. So this act, though the company has adopted the prescribed procedure, this act can be oppressive on me. Similarly, if I am having a more than 20% shareholding and I am the director on the board, and second group has more than 70% equity, they also have the director on the board, one director, and our understanding is the director constitution will not change, but legally more than majority shareholder can pass the resolution to appoint the another director, and they appointed, and I became the minority in the board. So it is oppressive on me, though it is a legal, they have done following the prescribed procedure. So this is also one of the example that one should be very clear about the facts of the matter. See, one more example I can give. There are two directors, two shareholders. There is a dispute between two. One director goes to the bank and give the letter that the bank operation should be stopped due to illegality done by other director. And bank stops. What is the remedy? Remedy is I will go to the Nclt and take the necessary direction that this is done illegally, because operation of the bank account cannot be changed without holding a board meeting. And board meeting cannot be held unless I am also available and present in the meeting. So these are some of the issues or things which we should consider and we should have carefully put into the petition. Next is how to appear before Nclt. This is what I am saying, just a practical experience, what I had in previous years, what is happening in the court and how members can take benefit of it. See, one thing I will say, there is nothing special in appearance before Nclt and Clat. It's like the same you are appearing before ITAT. So many members are appearing in ITAT, but there no member coming into the Nclt and Nclat. First of all, we have to maintain preparation for the appeal, this appearance. First of all, dress code. Dress code is according to your professional dress code. You have to adopt that. If I am a lawyer, I will wear my dress, gowns, band, etc. If we are the chartered accountant, then they can have the suit and tie. Then I have to see the matter. What is the matter I am going to argue? What are the pleading? What are the provisions of the act? This all you have to keep with you. What are the pleading means? Petition, their reply, rejoinder. This all have to be along with you when you go for the appearance. Third thing, if I am going to rely on any judgment, then the judgments we have to keep in our folder and we have to give the cross the bench. Not in virtual hearing. Nowadays virtual hearings are going on, only citations are being given, but practically it is being given. For the judgment, I must say one thing. Before giving the judgment, we have to very ensure that that judgment is not challenged in the higher court. If it is challenged in the high court, you should not refer that judgment. Then your power attorney or wakalatnama, whatever it is, for you, it's a power attorney. For lawyers, it's a wakalatnama. So this is the preparation for the appearance before Nclt or Nclat. Next is court proceeding. You have to be on time, never get late. Then before starting, you should say to the court whom you are representing, whether petitioner, whether respondents. In respondents also, so many respondents, which respondent you are referring. And then with the permission, you can start the arguments. In argument, you must be very precise and crisp, not very lengthy arguments. And you should not argue beyond your pleadings. Whatever you have said, you should go for the pleading only. So you should not argue anything which is against or beyond the scope of, which is not in the record of the court. When you argue, you should not mislead the court. Whatever facts are known to you, you should inform to the court. Do not mislead the court. Because here there is a opposite counsel is there. If you say anything wrong, he will make the objection. So don't try to mislead the court. And you should not cross argument. If some other counsel is arguing, whether he is arguing wrongly, your turn will come, then you can revert on it. But don't do the cross argument at the same time. And judge, you should not interrupt the judge. When judge is speaking or asking any question, you should listen carefully and reply that question immediately. In general, you should not accept the assignment or the for the appearance if you have the conflict of the interest. Conflict of the interest, that you should not appear for your blood relative, or you in person you can appear, or if you have given any guarantee in that matter, or you have signed any witness as a witness, you have signed any agreement in that matter, you should not appear, because that it will be the conflict of interest. And don't stand surety for your client. To sum up, now I must say that Nclt or Nclat jurisdiction is excellent jurisdiction, very wide jurisdiction. Anyone can adopt this as a main branch of his or her practice, because one thing is very important. You are in this practice, you are responsible to your client only. And like in chartered accountant practice, you are signing the certificates, you are signing the balance sheet. Here we don't sign anything. Everything is signed by the client. But don't mislead the client also. though there is no responsibility, and act in a dignified manner. So friends, I will just make a summation that this jurisdiction is very, very good jurisdiction, remunerative and interesting also. So anyone can use this jurisdiction and go for the appearance to act as a RP, IRP, liquidator, and of course, senior member can become the technical member of the benches. Now questions. You are.
Sir, there is no question yet.
There is no
Carry
question.
on. No question.
Acha.
Detailed deliberation by you, sir.
Deliberated in such a manner, it's so clear and given the insight. There is no question at all.
सर मैं एक चीज और बता दूं, सर को सैल्यूट करता हूं कि सर अभी कोरोना को हरा करके आए हैं। कोरोना से लड़ करके आए हैं, बड़ी लंबी लड़ाई, और स्टिल हमारे साथ है और सबको नॉलेज डिस्ट्रीब्यूट कर रहे हैं सर।
नहीं, it's my privilege.
That's all to you, sir.
No, thank you so much. Thank you so much. Thank you so much.
क्या हो गया?
No, I had corona.
Oh my God. तो अब
Now
सब
is
ठीक है?
okay. Now is
Everything
okay.
is fine. I am before you.
या तो मतलब बात हुई नहीं ना, और ऐसा है ना, जो क्वेश्चंस की बात है, आप इतना अच्छा एक्सप्लेन कर रहे हैं तो क्वेश्चन सब चीजें इतनी प्रॉपर समझ आ रही हैं, तो क्वेश्चन का वो बनता ही नहीं ना, क्वेश्चन क्वेश्चन नहीं बनते ना।
No, I had given just practical things. It's not.
मतलब you have very well explained each and everything. मतलब सब सीएस को प्रॉपरली समझ जाओ। अभी तक जो हमें ये लगता था यार ये तो एडवोकेट्स का मामला है, सीएस के लिए नहीं है, बट नाउ वी अंडरस्टैंड कि भैया हाँ नहीं, वी कैन go for this.
No, you should. We can. We should. Because I tell you, it is a so good and interesting subject that every day you will get a new thing. See, you never know the next client will come and give you what kind of the matter and what is the issue involved. Sometimes very small client comes with a very big issue. And that issue we have to study very hard. Sir, in this practice, I must say one thing, that people have to study very hard. They have to go inside. They have to read the orders, latest orders. Otherwise, you will not be successful.
What I could understand that everything should be concise, precise, and
Correct.
well documented.
Correct.
Documented.
Correct.
Yeah.
सर नाउ क्वेश्चन अब आने शुरू हो गए हैं,
Very good.
और अभी पहले जनरल नॉलेज से रिलेटेड है, वो भी मैं आपको सब कर देता हूँ। जतिन गुप्ता जी पूछ रहे हैं, व्हाट इज द प्रोसीजर टू बिकम इंसॉल्वेंसी प्रोफेशनल?
Yes, Jatin ji, you can become the professional. You have to go to IBBI site. Their total procedure is written. You have to pass the exam. It's a 1 hour exam, and it is covered IBC. It's covered Companies Act. It's covered Contract Act. It's covered Sales of Goods Act, and so many other acts. But more than 50% question comes from IBC and the Companies Act. So you can very well study it, and it's online exam. Nowadays, I think it is suspended, but it will start very soon. You can become a resolution professional on passing that exam. Before passing, you have to get it registered with the entity, that is ICAI. Our institute has the entity. There you have to register. And then you can become a member of IBBI.
Next question Surendra ji पूछ रहे हैं, sir, I am practicing since 9 years as a chartered accountant. Can I for IRP?
Yes, why not? The procedure is the same.
नहीं 10 years की requirement है ना sir?
No, 10 years की कहाँ है?
अच्छा नहीं है.
उन्होंने बोला उसके लिए टेक्निकल
सर वो
मेंबर
टेक्निकल मेंबर्स के लिए 15 साल किया है.
ओके ओके ओके. तो सुरेंद्र जी आप बन सकते हो IRP.
Not only IRP, he can become IRP, he can become RP, he can become liquidator.
जी सर, जी सर. नेक्स्ट क्वेश्चन है परमजीत सेठी जी पूछ रहे हैं, is there any exam for applying for the technical membership of the NCLT?
No exam. The regular vacancies are published in newspaper. You can apply to it, and there is a prescribed procedure for appointment of technical members.
ये anonymous attendee है, इन्होंने नाम अपना नहीं दिया है. How to prepare IBC insolvency exam?
How to prepare? I told you, you have to study IBC, you have to study Companies Act, you have to study Contract Act, you have to study Sales of Goods Act. These acts, if you study properly, then you can pass, because 60% is the passing requirement is there.
Next question सुरेश भंडारी जी पूछ रहे हैं, are the court working? Are the court working?
No, courts are not working. Courts are not working physically, but virtual hearings are going on. Today, I appeared in one matter in Nclt from home only. Only important matters are being taken up. For that purpose, the guidelines are issued. You have to first file your request for urgency in the matter to the registrar. Give brief of your matter. What is the pleading are completed or not? If pleadings are not completed, then why there is a urgency? If registrar thinks that it's an urgent matter, then he will put for the virtual hearing.
Next question योगी राज जी नवाले हैं और बॉम्बे से हैं. Whether limit of filing a case for insolvency has been increased from 1 crore? Yes, वो तो है.
Yes, yes, it has been.
हाँ, it is. ठीक है, it's okay. Next question नरेश मुंजाल जी का है. Question नहीं बल्कि उनका एक थोड़ी सी increase of knowledge है. There are more opportunities for CA like acting as transaction auditor, consultant for resolution applicant, or submission of resolution.
Yes, I agree, because there are so many other, but I have just covered what are related to NCLT only, appearance and and the how to involve in the. Otherwise, IRP and RPs are authorized to appoint any person for transaction audit, forensic audit, this this consultant, day-to-day consultant also. So these opportunities are there. I agree with him.
Next question है योगी राज जी का again. What are the relief given by the government during COVID-19 pandemic to those entities whose businesses suffered during this phase?
See, very important benefit which it has been given is during the COVID, from 25th of March till today, if any dues become overdue, for that reason, for that cases, this petitions cannot be filed. Insolvency petitions cannot be filed.
और
And
limit
there
भी
will be, yeah, for 6 months. Initially for 6 months, and it can extend for another 6 months.
limit is also increasing 1 lakh to 1 crore.
Yeah, this is also already increased. This is already increased.
One question sir in chat box में है, मैं उसको पढ़ रहा हूँ. कहाँ गया अभी तो क्वेश्चन था. Kindly aware us regarding the myth in the industry that there is a high pressure as well as threat on IRP during investigation. Very good question, sir. This is a practical problem.
Yeah, it's a practical question. See, one thing is very important to understand, that when you will do the any kind of the assignment, the threats are already there. And I will say one thing only: be very specific about your assignment, and do diligently. And if you do everything right, our guru Mr. Amarjit Chopra ji says, if you do everything right, don't worry, nothing can be done. So investigation or whatever it is, see, if you have done nothing wrong, you should not worry. So my just suggestion to the member is that whatever assignment we are doing, we should do diligently, and we should utilize our full knowledge for that.
एक क्वेश्चन है सर अगेन, प्लीज एलोबरेट द डिफरेंस बिटवीन आरपी वर्सेस आईआरपी वर्सेस लिक्विडेटर फ्रॉम प्रैक्टिस पर्सपेक्टिव.
Yes. See, IRP, RP and liquidator.
Yes, sir.
Qualifications are the same. See, initially when application is admitted, that the person appointed will be called IRP. His initial period is 30 days only from the date of appointment, and he has to do the initial work. Like, he has to take over the assets of the company and charge of the company. He will give the advertisement, public advertisement, inviting the claims. He will collate the claims, and COC will be constituted by him. And first meeting he has to conduct within 30 days of his appointment. That is the first IRP's term is to be terminated. But same person can be appointed RP by the COC, or COC may change any other person by. That RP's tenure will be another 330 days, during which he will conduct the COC's meeting. He will prepare the memorandum of information, expression of interest. He will give the advertisement for inviting bids. He will get the bids, and then he will submit the bid to the COC and file different application during this period for the purpose of reports, etc., etc. And if he gets the plan approved by the COC, then he will file the resolution plan before Nclt, and then Nclt will approve that plan. This is, if it is approved, no need for the liquidator. If no plan has come and 330 days have been lapsed, then the Nclt will appoint the liquidator. Same person can be appointed as liquidator, or Nclt can appoint another person as a liquidator. So this is the total trail of the IRP to liquidator.
Sir, now next question सुभाष जी पूछ रहे हैं, whether MCA annual filing date has been extended?
Not yet.
Is there any chance?
Yes, I can't say. It depends on the MCA. Normally, in these kind of the circumstances, and we all aware, these kind of the decisions are being taken 3-4 days back, before the deadlines.
सर एक क्वेश्चन है सुरेंद्र प्रसाद जी का, और उसके बाद एक बड़ा इंटरेस्टिंग क्वेश्चन है सर, उस पे आपकी तो जरूर हम चाहेंगे कि अपने आप व्यूज दें. पहला क्वेश्चन है, सुरेंद्र प्रसाद जी पूछ रहे हैं, कैन वी होल्ड COP along with membership of IRP? Yes.
Yes, sure.
Yes,
because you are registered by ICA in the Nclt.
Yes, sir. Yes, sir. Yes, sir. नरेश मुंजाल जी, हमारे NK मुंजाल जी, very senior member, having office at Lajpat Nagar. He is saying Saxena ji hats off to you, giving a beautiful presentation after fighting COVID. Please also advise how to fight with COVID.
See,
Please share your.
you must be watching television every day, but I have gone through this. You will say time of 7 days. 7 days, very important days. See, here one thing I will say, so far as precautions are concerned, drink hot water. I am not drinking normal water for the last 2 months. Hot water. Do exercise for the like Brahmari, Annom Vilom, like that. So it will give you the strength to your this
Immunity.
body, immunity. And I must say, Rajesh,
Ji.
there is no specific medicine for that. See, people are giving this vitamin C, HCQ or something, and you have to, your mindset should be very clear, though it's very difficult during that time. See, I told you, Rajesh, that day that if you are going to the hospital with this COVID positive, what the thoughts were going in your mind?
Negative thoughts.
And for the 7 days you are in bed, and what kind of and you are not surrounded by any of your nearest dears. So what kind of the thoughts you must be having in your mind, and how to fight that? See, it's just a mindset. Though it's very difficult.
Very difficult. Correct. I
And
appreciate.
see, oxygen level, your oxygen level should not be go down. It's very important. And
One should keep
I
checking,
must
sir.
say, किसी दुश्मन को भी ना हो.
सर आपने अभी एक बात कही कि इसकी कोई स्पेसिफिक मेडिसिन नहीं है, फिर भी बिल लाखों में आता है सर. व्हाट इज द रीजन?
So Rajesh ji, this I can't say because it's and particularly on this platform, I can't say. See, I can't make a comment on it because it's a wisdom of the medical person, doctors, hospitals. That is their wisdom.
ठीक सर. अच्छा, 4 क्वेश्चन और आए हैं सर. 4 क्वेश्चन.
बोलो, कोई बात नहीं.
विशी भंडारी जी पूछ रही हैं, सर कैन यू शेयर केस स्टडी ऑफ हाउ प्रोसीडिंग वर्कआउट? ये इनकम्प्लीट क्वेश्चन लग रहा है मेरे को. सर कैन यू शेयर केस स्टडी ऑफ हाउ प्रोसीडिंग वर्कआउट? इससे रिलेटेड है, इसी से होगा एनसीएलटी और इससे
वो ऐसा है. ये राजेश जी लगता है जनरल क्वेश्चन है कि प्रोसीडिंग के अंदर कैसे अपीयर होना है.
देखिए, मैं आपको एक चीज बता दूं इसमें.
जी.
आपने अपीयर होना है, सब कुछ आर्गुमेंट कर देना है. एक चीज ध्यान रखना है, जज से कभी भी ज्यादा आर्गुमेंट मत करो, ठीक है? और यू हैव टू से ओबलाइज्ड, यू हैव टू ओबलाइज द जज और बेंच इवन इफ ऑर्डर इज अगेंस्ट यू.
यस सर, वेरी राइट. Next question is,
we are been following with the ITAT.
Yeah.
Same procedure as we've been following in the ITAT.
I am saying there is nothing difference between the ITAT and the NCLT.
भाई जज के सामने आपने ज्यादा बोला तो आपके अगेंस्ट.
मेरा एक और सजेशन है टू ऑल द मेंबर्स, व्यूअर्स, that you have to have the inside knowledge of the subject if you want to appear before NCLT.
Correct.
it
Because
is must.
It is must because
it is must.
Sir, it is not an assessment proceeding where you can say I will file tomorrow, I will give tomorrow. See, if opposite side raise any question, you have to answer immediately. You have to counter immediately. Unless you have the insight and depth knowledge, you can't do that.
Correct.
Sir, next question है Yogi Rajji from Bombay. Is there any specific relaxation given to MSME from IBC?
It is underway actually. Some proposals have gone for MSME, and I think it will come out within few days.
Okay. Anonymous attendee पूछते हैं, in IBC proceeding in a builder case, is project wise or not?
See, there is a Supreme Court judgment that, not Supreme Court judgment, it's a Nclt judgment that it's not a project, it's a project wise, not by the company wise. Suppose company has the 3 projects. One is Noida, one is Gurgaon, one is Chandigarh. And there is a problem in Gurgaon project. So Chandigarh and Noida project cannot be involved in that proceeding.
Okay. Is a project
I
wise.
think I have cleared it. I think I have cleared that thing.
विद्या खन्ना जी पूछती हैं, we have to work under IRP to gain experience and then give exam and apply for IRP. It's a good suggestion. It is a suggestion.
It's a suggestion. I will say one thing more. When physical hearing starts, you go 1 week to the Nclt court and see how proceedings are going on. That will be giving you more insight of the IBC proceeding.
Yes,
See,
sir. Yes, sir.
some senior member came to me long back and he says, ki, Arun ji, how to do the justice to my RP responsibilities. I say you go one week to the court, different RP matters are being handled, and there you will get the maximum insight. And he said, ki, yes.
Next question है राजीव सब्बरवाल जी पूछते हैं, has the application to NCLAT now postponed till March 2021? If a company has any due from the company and they are not paying, can we file the application or the moratorium extended till 31 March 2021?
See, not all the dues. If dues falls between after March 25th, then you cannot file. Suppose
Okay.
I give the example.
Yes.
Suppose my invoice were issued in 2019 and it is due in January 20. I can file today because it is not during that period. The
Okay.
moratorium is if invoice dues or dues come payable during this period, moratorium, this 20 after 25th of March.
अच्छा, ये नेक्स्ट क्वेश्चन राजीव जी का, ये अंडर आईबीसी व्हाट इज द स्टेटस ऑफ द एप्लीकेशन एट प्रेजेंट?
Which application?
जो अभी पिछले क्वेश्चन में थी ना सर, ये
तो वो तो थी, फाइल करें या ना करें?
2021 तक एक्सटेंडेड कर दी ना उसकी डेट?
नहीं कर तो दी, वो फ्रेश फाइलिंग के लिए करी है ना.
ओके ओके.
जो ऑलरेडी 25 मार्च से पहले मेरी फाइल हो गई है एप्लीकेशन, वो तो सुनी जा रही है.
अच्छा, इनका ये फिर आ गया राजीव जी का इसमें रिप्लाई, द बिल्डर एंटर्ड इनटू जॉइंट बिल्डिंग एग्रीमेंट बट डिफॉल्टेड बिफोर 25th March and has to pay damage before 25th March 2020. So they can file, no problem.
Yes.
They can file.
वो तो उन्होंने टारगेट डेट बना दी है ना, 25th मार्च से पहले के कुछ नहीं होगा, उसके बाद के होगा.
Okay sir, there is no question now. Thank you very much.
Thank you Rajesh ji.
And request our Ashwani Katpalia ji, please present a vote of thanks sir.
Ashwani is you know my co-founder member.
Yes sir. We are all sir, we are all. हम स्टार्टिंग में तो 5-6 जन ही थे सर, हम सारे बैठे हुए हैं.
Yes.
We are all here.
भैया ऐसा है, या तुम तो को फाउंडर मेंबर की बात कर रहे हो, मैं तो भैया हम तो को आर्टिकल्स हैं.
हाँ, को आर्टिकल है, हम लोग को आर्टिकल है. यस.
तो भैया हमारी ऐसा है, पहले तो राजेश जी आपका धन्यवाद, मुझे उस बंदे को थैंक्स करने के लिए कह रहे हो जिस बंदे को मैं हमेशा थैंक्स करता रहता हूँ।
अरे
Yes,
क्या
sir,
बात
yes.
कर दी अश्विनी यार।
देखो, he lives in my heart.
ओह,
ठीक है, there are very few persons जिनके साथ आपकी हार्ट टू हार्ट रिलेशंस होते हैं,
जी सर,
and
जी
he
सर.
is one of them. और my association with him very long. वो तो अगर मैं उस पे बोलने लगा तो भैया जितने देर का वो नहीं हुआ सेमिनार,
years.
उससे ज्यादा तो थैंक्स हो
I
जाएगा,
think
वोट ऑफ थैंक्स हो
I
जाएगा।
think it's 40 years, more than 40 years.
So, but he has very well explained, as I said earlier also, and he has very well suggested, you have to have in-depth knowledge, have to draft, it has to be concise, it has to be precise, it has to be well drafted, well documented, and you have to be in-depth knowledge of the subject. Then only you should, but it is a great opportunity for all of our professional colleagues. I thank, on behalf of Pusa Road Study Circle, I thank on my behalf, and I thank him very well, and he has very well explained, very well deliberation, or thank you very much for enlightening us by beautiful deliberation.
Thank you,
Thank you very
Ashwini.
much. Thanks a
Thank
lot.
you so much.
सर हमारे
And-
धमीजा साहब कुछ कहना चाह रहे हैं। सुनील जी, धमीजा जी सर, गुरु जी।
जी बोलिए
एक
सर,
शब्द
धमीजा जी।
हाँ,
पूरे
over to धमीजा जी।
full-heartedly thanks to Saxena ji. Arun ji is a lovable personality. Apart from the subject, otherwise also he is lovable.
Yes,
Yes,
मतलब
sir.
that is why I said, धमीजा जी, इसीलिए मैंने कहा अगर मैं उस पे बोलने लगा तो भाई फिर तो लोग जो है घर चले जाएंगे और हम ही बात करते रह जाएंगे। तो ये तो
उसके लिए एक प्राइवेट मेल डाल देना ना आप।
हाँ, वो मैं रात को बात करूंगा। नाउ इट मतलब जैसे ही आपने राजेश जी बताया ना, तब से मेरा दिमाग जो है आई एम अपसेट। एक्चुअली मैं अपसेट हूँ क्योंकि जो चीज मेरी इट वाज नॉट टू माय नॉलेज और मेरी गलती है। जनरली आई कीप ऑन टॉकिंग विद हिम। मैंने एक डेढ़ महीने से बात ही नहीं करी, मतलब
मैंने किसी
चलो।
को बताया नहीं था।
हाँ,
हाँ, वो तो हमें पता, मेरे को पता लग गई थी सर। बताया मेरे को भी नहीं था, लेकिन पता लग गई थी मेरे को। सर एनीवे, धमीजा साहब।
बोलिए
Thank
धमीजा
you
जी।
very much, Arun ji, very much. You are well deliberated on the subject with a complete insight, giving the complete details, information of appearance, preparation, appearance, and the technical legalities of the subject. We are really thankful to you.
Thank you so much.
Thank
Thank
you,
you
sir.
all.
Thank you.
Thank you.
Thank you. Thank you.